Thank you. I will. We'll begin today with Mr. Richard Roche, who will be followed by Charles Riley, Jeanette Gioia, Cameron Roberts, Joseph Quinn, and Brian Vickers. You can begin.
Push. Again? Okay. Sorry. And I'd like to be able to shorten the proceedings by just saying ditto. I agree with just about everything said here today, and hope not to repeat much of it. I've shortened my prepared remarks just to do that. My name is Rich Roach. I'm the Vice President of International Transportation at Mohawk Global Logistics. I also serve as Chairman of the NVOCC Subcommittee at NCBFAA, a role I've held for the past 8 years, and I speak here today not just as an active NVO, but as the voice of the many small to medium-sized NVOs that are part of our membership and for the customers who ultimately bear the brunt of unexpected costs. I've been in the industry for just about 40 years, first sailing on cargo ships, working on the carrier side, and shifting to the NVO side 24 years ago. I'm here today not to eliminate demurrage and detention, I'll just refer to as D&D to keep it shorter, but rather to seek a solution that such charges may be applied fairly, with more transparency in their application and more standardization where additional free time should be granted. As an active NVOCC, Mohawk regularly works within the confines of standard free time, 4 days to evacuate containers from the pier, 2 days from the rail ramps. Our clients expect us to pull their containers within free time so as to avoid D&D charges, otherwise we would pull and store them off dock. We understand that D&D as it exists today is designed to incentivize rapid pickup and return of containers with punitive consequences for those that don't perform. That system works most of the time. It's the deviation from the norm that becomes the basis for our complaint. Congestion from any cause, labor, system crash, vessel bunching and weather, or terminal glitches like lost containers, closed sections of the yard, and in some cases equipment shortages, may contribute to D&D being assessed unfairly due to circumstances beyond our control. We talked a lot about congestion, so I'll keep this brief. When caught in heavy congestion scenario, it is extremely difficult, if not impossible, to find anyone at the carrier or the terminal to negotiate extended free time. When we do get somebody, they might argue that the line is not 6 hours long because they only see 2 hours of the backup. But meanwhile, our trucker's geofence shows him slowly advancing, in line, wrapped around to the other side of the port. There's an interesting difference in the point of view of those collecting the charges and those paying. We have an agreement with our house drayman to pick up 25 containers a day at the Port of New York. If we have 100 containers arrive with first availability on Monday, we can get them all out by Thursday. And we don't incur demurrage in those cases. But when there's a problem at the terminal on Monday, and we can't get 10 of those containers out on that day, without making other arrangements, we'll be in 10 days of demurrage by Friday. And if we have 10 containers each day that we don't pick up through the course of the week, we'll have 40 containers in demurrage on Friday. And in these periods of congestion, there are no other draymen to go to. They're all in the same situation, so we're stuck. We just have to get that pushed out, and there's no control that we have over collecting those containers. Commissioner Dye's report on supply chain highlighted the disconnect between MTOs, carriers, and shippers. Certainly there is a disconnect. We're left to beg for refunds after the fact because we don't have a voice at the table. And when we beg, many times this falls on deaf ears. We've heard a lot today about congestion and the variety of situations that are caused through congestion, but I want to talk a little bit more today about the day-to-day problems that we have that are not congestion related, and I'll give you an example. I have one live situation working right now. Our trucker got availability for our container on the West Coast terminal in mid-November, but the first available appointment was 4 days into demurrage. The trucker began an appeal for extended free time with the terminal, but had to pay the demurrage on the day of the dray appointment because the extended free time was not granted until later that day, and this is cash on the barrelhead. When he got there, the container could not be located for a couple of hours, and so he was terminated from the terminal. He was escorted out. When he then went back onto the line to apply for the demurrage again, to apply for an appointment again, he was also put in 4 days of demurrage, prepaid those charges, and then went to get the container for a second time. At that point, he went to the spot that they assigned him for the container, demonstrated to the terminal that it wasn't there, and went out of the terminal. Third time was the charm. He was able to collect the container, though no clear response was given on extension of free time again, and we're still trying to get a refund of $1,700 in demurrage paid by the trucker. We talked earlier this morning about risk, and demurrage notwithstanding, we assumed risk in this case, with additional costs of 2 weeks of delay, truck waiting time in the terminal both times, and 2 dry runs. That's the risk on our side that we have to bear, in addition, very likely to demurrage. I'm still waiting to have this $1,700 refunded. Getting back to congestion, we polled our membership at NCBFAA about statements made by MOL in this proceeding regarding its ability and willingness to negotiate demurrage and detention. Our association had 89 responders to this survey. That's about 10% of our members. 93% of them said they have been assessed demurrage and detention charges in periods of congestion. 94% of the respondents did not agree that MOL worked out an acceptable arrangement or compromise, and 89% indicated the same for the rest of the industry. In other words, that they were not able to work out an acceptable arrangement or compromise to mitigate demurrage and detention charges. The reality is there's little incentive for the carriers or MTOs to want to change the current process. It remunerates them when the delays are caused by the shipper, trucker, or NVOCC, and rightfully so. When the carrier or terminal is the cause of the problem, however, they can simply stand behind their tariffs to print money, with no incentive to fix the problems or even entertain the argument. Further, they have unilateral power to decide who pays and who gets absolved after the fact. This has to change. We agree with the remedies proposed by the coalition so that there's some equitable shift of burden in these cases. In our view, the FMC should issue an interpretive rule so that triggers are established that automatically extend free time for certain causes. Carriers are not permitted to hold up container release when claims are asserted, only to add even more demurrage, and that the punitive portion of demurrage charges be rescinded in force majeure cases. In conclusion, the status quo is unfair, patently discriminatory, and burdensome at best. We would like to see the Commission put the burden on carriers and MTOs to justify detention and demurrage costs when the importer, exporter, and their agents are not at fault. And we would also ask the Commission to consider exempting detention and demurrage charges of tariffs from the Shipping Act so that they cannot be enforced under filed rate doctrine. Thank you for your time.
Good afternoon. I'm Charles Riley. I'm the chairman of the New York, New Jersey Foreign Freight Forwarders and Brokers Association, and also Vice President John Steer Company. And I will be giving a joint statement also with Ms. Jeanette Gioia, who is our Vice President of the New York, New Jersey Foreign Freight Forwarders and Brokers Association. Acting Chairman Michael Corey, Commissioner Rebecca Dye, Commissioner Daniel Maffei, and Federal Maritime Commission staff experts. Good afternoon, and thank you for allowing us the opportunity to comment on the rulemaking issue raised by the Fair Port Practices Coalition. The NYNJFFBA celebrates 100th anniversary this year as one of the oldest U.S. trade associations for licensed ocean freight forwarders, MVOCCs, and customs brokers. It has 100 regular members and 25 industry-related affiliate members, ranging from the largest global logistics carriers to the smallest mom-and-pop shops. All these companies operate on a daily basis, facilitating the movement of imports and exports through any port in the United States. Our comments today will largely focus on those issues in the Port of New York, New Jersey, where our membership is located, and the support for FMC guidance on what would constitute unreasonable practices in assessing demurrage, detention, or per diem. They are provided in the context of a strong belief in the role of competition and the effectiveness of commercial solutions to business problems. Our members' interest in having the FMC provide guidance on this issue stems from a deep frustration that a full market solution is not possible. The economic structure in the Port of New York and New Jersey is more characteristic of an oligopoly rather than a competitive market. In the oligopoly, barriers to entry are high, thus restricting the number of companies providing services and limiting pricing flexibility. In New York, New Jersey port, over 3.6 million general cargo containers are moved through 5 main terminal operators. The shipper-receiver does not have a choice of which terminal to use. This is determined by the steamship line. While there are 32 steamship lines calling New York, New Jersey port, this number is significantly reduced for any particular port pair. This structure supports an inflexibility in pricing and service options that allows a shipper-receiver to be assessed charges, even in circumstances when they are not in control of the cargo. Our membership believes they should not be responsible for the payment of demurrage and detention in situations when their ability to move the cargo is clearly outside their control. The NYNJ FFFBA has polled its members and found strong approval of the need to clarify what would be considered unreasonable assessments. We had over 70% response from our regular membership. This would be on the high end of survey completion rates and indicative of the intense interest in this issue. Even some of our affiliate members answered to the survey.
We asked just a couple of questions because we really were trying to understand how deep the problem is. And the focus was always on what was reasonable, what was unreasonable, because we fully understand the importance, the need for steamship lines, terminals to be reimbursed for use of their equipment and space. But what we've all suffered is a situation that is actually out of control. So we asked a question: should the FMC establish a rule with a policy statement clarifying when the assessment of demurrage and/or detention would be considered unreasonable in circumstances that are beyond the control of the shippers, the receivers, the motor carriers, and prevents them from picking up or delivering cargo? So we really only focused in those instances of unreasonability. We have 100 members, regular members. We had more than 70% as Charles pointed out, responding. This is a high number for a survey. 72 out of 74 answered yes. Yes, the FMC should establish a policy statement. In the 3 instances where amongst our regular members where they said no, 2 of the companies had actually not been experiencing any kind of a problem in this area. One of the 2 respondents is one of the top 10 global logistics companies, and they actually said, not surprisingly, the terminals are cooperative. So we'd like to really bring to the attention of the Commission that the current system is inherently skewed against companies that do not have the negotiating leverage with the ocean carriers in the terminals to reduce or eliminate the demurrage. And these are charged per tariff rules and rates, and often that is exactly the way it's expressed to our community. Second question that we asked was, have your company or your clients had to pay demurrage and or detention charges in the Port of New York and New Jersey when equipment could not be picked up or dropped off? Again, the emphasis was due to circumstances beyond your control. And we divided it up. We asked prior to 2017. 63 responded yes out of the 74. And then we asked during this past year, 2017. 49 responded yes. So there was a reduction. What we found interesting was that among the members that had not experienced problems with being unfairly charged demurrage and detention, there still was support for a clarification on what would constitute an unreasonable charge. The comments indicated that companies are also experiencing unreasonable assessments at other U.S. ports. So we were asking the question in terms of New York and New Jersey, and some hadn't experienced it, but that also had experienced it at other ports. Survey results show that that the assessment had diminished, had lessened in 2017. We actually believe, in part, that is a direct reflection of the very existence of this petition submitted by the Coalition of Fairport Practices. That it actually even had some effect in mitigating circumstances that arose in 2017 and how there was a response on the part of the terminals and the carriers. Even though members commented that the terminals are showing more flexibility, they've also pointed out the ongoing challenges of moving the cargo efficiently through the port as the trade volumes have grown and the size of the ships discharging the cargo have gotten larger and larger. So it's not a one-off problem. It's something that is continuing. The issues that the members expressed in terms of under what conditions they were experiencing unreasonable detention and demurrage. It related to port congestion created by extraordinary events, the weather, labor, computer failure, government action. Many of our members expressed a lot of situations where customs examinations related both to import and export shipments. They found it very frustrating that steamship lines are charging for the equipment usage when containers are moved off the New York, New Jersey port into one of the few central examination sites. Before the CES system was put in place and when the examinations were being done actually on the terminal, steamship lines were not charging for the equipment usage. Only the clock would only start after the government released from an exam. Substantial costs are now accruing. As soon as those containers exit the terminal, they're going to the CESs. The steamship line equipment charges kick in. The importer has absolutely no control over when or where the cargo will be examined, and we believe they should not be in a position to bear the punitive extra cost. In addition, the other areas that were cited causing for detention demurrage, lack of equipment, truckers. We had an instance. Member said trucker was not able to pick up at a terminal because there were no gensets available, and this truck was on the line. Then finally was left the terminal, no gensets. A genset came free. Trucker goes back on the line. It was already too late, and free time was charged in that instance. Also, there are inabilities to obtain a terminal appointment, which moves into the expired time. And then steamship lines delaying or changing action, which leads to demurrage for goods at the terminal, at the arrival terminal, or at the rail yard. In fact, when we were just prior to coming into the meeting, Charles' phone lit up with exactly an example of a situation at the rail yard.
Yeah, what happened was there was an inland move to an inland terminal, actually to Columbus, Ohio. The vessel called Norfolk, Virginia. My company, which was a customs broker, cleared the shipment before it even hit Norfolk. We sent out the delivery information to the carrier before it even got to Norfolk. So they had plenty of time to be able to issue the delivery instructions before the container even arrived in Columbus, Ohio. We then received information that from the steamship line to be able to guarantee 5 days of demurrage at the railhead because they could not have the truck power to be able to move it out of the rail yard. And we find that really hard to believe when we gave them the instructions way beforehand. What our understanding is that it is possible, since I don't work for the steamship line, but that their SOP is that they issue the instructions to the motor carrier. They don't hand them out until the trailer is actually available at the rail yard. So they only have 2 days to be able to pick it up. So they put us in the BCO. They really put the BCO at a disadvantage. And what a lot of this comes down when you hear the testimony before us in the last session. The risk when these containers come in, the risk is all thrown, as Rich said, the risk is all on the BCO. So that even if there's a weather-related incident or any other information, you're in business, you have to accept a certain amount of risk being in business. And it seems like all the risk for these containers is thrown on to the BCOs. The line doesn't want to accept any, and the terminals don't want to accept any. So basically, the New York, New Jersey Freight Forwarders and Brokers Association favors the FMC providing additional clarification and interpretation of what would be considered an unjust and unreasonable practice and not allowable under Section 10D of the Shipping Act of 1984. Thus, our membership is in agreement with the Pro's statement of policy in the Fair Practices Petition, Exhibit A, that ocean common carriers and marine terminal operators will be acting unreasonably if they are unable to tender the cargo for delivery and or to receive equipment due to circumstances beyond the control of the shipper. This would mean that 1. Free time should be extended if the occurrence preventing cargo delivery or equipment receipt happens within the free time. Also, that the free time should be granted for the period in which occurrence happens, even if the free time has expired. In conclusion, the New York, New Jersey Freight Forwarders and Brokers Association supports the petition's comment that the FMC guidance on detention demerits practice to ensure that ocean common carriers and marine terminal operators use these charges as intended and to provide an incentive for the efficient handling of cargo and equipment and not as an additional revenue source. Our membership supports the FMC establishing a rule of guidance to help clarify when the assessment, demurrage, and or detention would be considered unreasonable in circumstances beyond the control of the shippers, receivers, and motor carriers and preventing them from picking up or delivering cargo to terminals. The current system does not have sufficient checks and balances to ensure that demurrage and detention are properly assessed. FMC guidance on what is unreasonable will assist in providing such a check. The New York, New Jersey Freight Forwarders and Brokers Association would like to thank the Commission for the opportunity to express our strong feelings of our membership on this issue and the hope that a more reasonable practice will result. This can only help facilitate the trade. I would like to remark that to quicken the time frame, there are instances that we also have in here that we can also address at a later time that, state instances that have happened to our members so that you understand what's going on, because it really recently, within the last couple of weeks, because of weather issues and all, it's really compounded the problem where there's a lot of congestion in the port of New York, New Jersey.
Thank you.
And as I said in the beginning, every witness should feel free to supplement answers and whatnot post-hearing. So,
Thank you.
Thank you and good afternoon, Chairman Curry, Commissioner Dye, and Commissioner Maffei. On behalf of the Foreign Trade Association and Roberts and Cahadras LLP, I want to thank the Commission for holding this hearing and accepting our request to provide witness testimony on the assessment of demurrage, detention, per diem charges during the periods of port congestion. My name is Cameron Roberts. I am the Foreign Trade Association's chairman and a partner at Roberts and Cahadras LLP. As a native Southern Californian who commutes to the port on a daily basis, I know what traffic looks like. You think you know what traffic is? Come to LA and I can show you. And I can assure you that I know what port congestion looks like. I've seen it out my window on a daily basis during the period of congestion last, looked at it from the Vincent Thomas Bridge, and all I can tell you is that what it looks like is dozens and dozens of ships sitting at anchor and thousands of trucks all waiting, and waiting. They're waiting for someone to take action. And we hope that the FMC is the appropriate party to take that action. The FMC members are part of a $1.4 trillion logistics industry, equaling 8% of the annual gross domestic product of the United States. Founded in 1919, the FTA's membership reflects the logistics industry as a whole, including freight forwarders, NVOs, customs brokerage, drayage operators, importers, exporters, and the like, who, like the FMC, are committed to encouraging just and efficient and reliable ocean trade transportation system. I am here today because port congestion, delay, and the assessment of these charges that we've been discussing during periods of congestion have created a huge inefficiencies in the marketplace, putting ocean logistics industry at risk, damaging the credibility of United States importers, exporters, and our ability to compete in a fair and free trade environment that we seek to participate in. The OTIs and their customers, the American importer and exporter, rely, and righteously, on the custodial carrier and the terminal operator. If Chairman Curry would dust off that book of Gilmore and Black, he would concur, I'm sure, that the carrier has a obligation under the general common law and under statute to deliver the goods on a fit and proper wharf. A fit and proper wharf is one that operates with reasonable efficiency. That duty is not being discharged, and that is why we are here today. In the ports of Los Angeles and Long Beach, port congestion is a byproduct largely of terminal negotiations, vessel alliances, and divestment of the custodial carriers in intermodal equipment. These are the primary issues. It is undisputed that the Shipping Act prohibits a custodial ocean carrier or marine terminal operator from engaging in an unjust and unreasonable practice, and thus you have the authority to involve the Commission in giving guidance. The collection of charges in the midst of port congestion is an unjust and reasonable practices, especially if the gate is closed. This would also be a violation of California law. However, the gate closure issue has become a shell game, and an open for business sign is an illusion fraught with frustration, commercial impossibility, and outright refusal by terminal operators to interchange containers even when they have valid appointments. Despite these known causes of port congestion, custodial ocean carriers and terminal operators have continued these practices despite flagrant violations of both policy and law. The practice of collecting these charges during port congestion encourages future congestion and unjustly and unreasonably shifts the cost of the inefficiency of the terminal on the OTI. If you believe that they do have the duty to deliver and on a fit and proper wharf, this cost shifting should be reflected not in demurrage assessed after the fact, but in the underlying rate. This is a backdoor way of assessing and shifting the fee and the risk. That is unreasonable on its face. Importers, exporters rely on the rates that they pay to create a landed cost calculation. That landed cost calculation assesses what is or is not a reasonable sale. If they cannot rely on the system, they have no sale, and we might as well just walk away from the global transactions and the global marketplaces that are necessary to help the American economy compete. OTIs and their customers need a reliable access to markets. The Hanjin bankruptcy created a catastrophic inefficiency when thousands of containers were randomly abandoned around the world. To offset the cost of the inefficiency and delay, marine terminal operators refused to handle, release, or receive Hanjin containers without upfront special off-tariff charges that were simply nothing more than a creation of one person's imagination in an effort to offset a cost of what they saw coming but did nothing about. Charges to offset those losses and expenses were shifted to OTIs and their customers, oftentimes saddling only the OTI who was caught in the middle and through no fault of their own. As I am on this OTI panel, it is important to point out that the OTI cannot prevent or resolve port congestion. OTIs do not determine the size of the vessel or its scheduling. OTIs do not control the decisions made by the custodial carrier in the course of loading or offloading the vessel. OTIs do not control custodial carrier's choice of a terminal operator. OTIs are not parties to labor negotiations. Accordingly, it is unjust and unreasonable practice to demand payment of charges by an OTI in this position during periods of port congestion. I've been involved in international trade for 29 years and negotiated hundreds of detention, demurrage, and per diem cases in the ports of Los Angeles, Long Beach, the United States, and across the world. My testimony is based on my experience as a licensed customs broker, a former OTI executive, an attorney representing hundreds of OTIs and motor carriers, past president of 2 local Southern California associations, and as an adjunct professor at the California State University Long Beach in its Global Logistics Specialist program. The FMC should adopt the petitioner's policy statement. Frustration and port congestion and the charges associated with unjust and unreasonable business practices are the reason I am here today. Those are real-world impacts that have a potential to choke the international commerce that we seek to promote. It will stunt economic growth if it is allowed to happen again. I respectfully submit that the Commission is in the best position to understand the real-world situations when it hears from people such as the members on this panel and the witnesses from the industry who have come before, because it is essential to this Commission's understanding the perspective of those who are being injured. It will be useful to the Commission to consider the petition's proposed policy, and I thank you again for the opportunity, and I thank staff for providing this forum here today. Thank you very much. Oh, sorry.
If I may, Chairman Corey, Commissioners, and FMC staff, thank you. Let me repeat, thank you for the opportunity to comment on the Coalition for Fair Port Practices petition. My name is Joseph Quinn. I'm president of Sefco Export Management Company and hold an FMC OTI Ocean Freight Forwarders license since 2007. I've been engaged in the business of U.S. exports for several decades, starting in my family-owned export company in the late 70s. Today, I perform OTI Ocean Freight Forwarding services, acting on behalf of often small businesses and individual shippers in all parts of the U.S. and world. I'm here today to speak up in strong support for the Coalition's petition. I support their call for the FMC to issue a policy statement to give support and guidance that will set boundaries for what is deemed reasonable conduct. There is a need for clarity regarding what could be considered unreasonable assessments, particularly in circumstances beyond the control of shippers and forwarders. Regarding my own experiences over the past 30 years plus, one incident in particular is etched on my mind. For almost 4 years, from August 2010 up through to 2014, I had to contend with an informal docket 1914I before the FMC. It proved to be terribly onerous, and its outcome to me seemed very unfair and unjust. The particulars can be read online at proexport.us. At the heart of the issue was port demurrage. In brief, the issue I had to contend with began with a trucker's overtime bill and a door move arranged by the NVO we booked the shipment with. Although valid, it was strongly contested by the shipper who self-loaded the container. Per our offer and terms, all charges were to be prepaid prior to export. We had to wait for payment, which eventually came in, however, late. Once that fee was received from the shipper, I immediately paid the exact amount to the NVO. The freight, which had already arrived in Miami, was released for export. The NVO informed me that the original Zim vessel it was booked for was missed. Thereafter, the NVO informed me that solely due to the steamship line scheduling issues, subsequent sailings were canceled. It took approximately 3 weeks more before the cargo was eventually loaded on the next available Zim vessel. When the ocean container was finally loaded on the ship, I was informed that over $4,100 in demurrage had accrued in the load port of Miami. A big shock. Neither the shipper nor the forwarder had any control over Zim's canceled sailings, nor the dwell time at the port once the freight was released. At the time of its occurrence, I sought guidance, including from the FMC, which would have been very helpful in addressing the issue. But I was placed in a defensive mode, having to answer an informal docket. I answered personally, thinking and hoping that the matter could be handled quickly. The alternative of hiring a specialist attorney, particularly for the several years' time it actually took, would have meant tens of thousands of dollars in legal fees alone. As someone who has dedicated the majority of my life and career to facilitating export shipments, I would have hoped to have had someone at the FMC, an OTI ombudsman, to offer positive help and guidance if and when such problems might occur. Fruitful collaboration would have been so much better. In some places and circumstances, container demurrage is a near certainty, given the short amount of free time versus the time necessary to clear and deliver. It's one of the biggest perils in this industry. Small shippers and forwarders simply do not have the leverage that large commercial shippers may have with the carriers and MTOs to mitigate or dismiss demurrage, but particularly when the clock is ticking. In the U.S., it seems that certain port operators have, over time, been decreasing the amount of free time at the ports, to such an extent that avoiding demurrage is like threading a needle. The general public has little knowledge of such things. This is why holding a public hearing today in itself is so important. Even the formation and existence of the coalition can itself have a beneficial impact on providing checks and balances. Of course, the prompt moving of cargo is critically important to the operation of MTOs. Demurrage and detention certainly serve a purpose. But by and large, MTOs seem to have practically free rein on such matters. Demurrage and decreasing free times may increase their bottom line profits, but have become a hidden tax, a kind of unjustified punishment, particularly on small businesses, and a bane on individual shippers. In some ways, it seems like extortion. Each port and terminal is different. Some steamship lines, like the Ro-Ro carrier Hogue, have been fortunate to be in a position to buy the real estate in several ports where their ships berth. They have become MTOs in their own right. That gives them much greater leeway in how they can accommodate their customers. Other MTOs, such as in New York, New Jersey, and Miami, may not have the same incentive as Hogue's operations. So, in regulatory terms, there is no one-size-fits-all solution. This is not a perfectly free market. Shippers often have no choice in what terminals to use. In some ports, MTOs, when left unchecked, have no incentive to negotiate or waive D&D charges incurred, even when resulting from conditions beyond anyone's control. It's quite clear in reading the verified statements and letters included in the petition that even large shippers often lack the leverage to negotiate better outcomes. Small shippers are in far worse shape, having little to no recourse. It's practically impossible to mitigate or dismiss demurrage, particularly when the clock is ticking. Circumstances beyond anyone's control, such as bad weather and congestion, can vary greatly. So there is no one regulation that will ever be able to match each situation. However, a policy statement by the FMC can help provide clear guidance and boundaries in regard to what is deemed fair versus unreasonable behavior. The FMC can help provide better understanding for both the problem and to find solutions for all parties involved without having to resort to often frustrating and lengthy processes and costly litigation. What has happened in the past, for good or bad, is not going to change, but we can and must do better. I am in full agreement with the proposed statement of policy in Petition Exhibit A. It's certainly a step in the right direction. Thank you.
Good afternoon, Acting Chairman Corey, Commissioners Dye, MFA. My name is Brian Vickers. I'm with here on behalf of the International Association of Movers, IAM. IAM is the household goods moving and forwarding industry's largest global trade association. With more than 2,000 members, its companies provide moving, forwarding, shipping, logistics, and related services in more than 170 countries for household goods shipments. IAM fully supports the policy statement put forth by the coalition, which would help bring about more reasonable demurrage and detention practices for household goods and other cargo moving through our nation's seaports. In addition to delays associated with weather, labor contracts, negotiations, and the arrival of very large ships, IAM member companies frequently experience additional costs and delays resulting from customs inspections and examinations due to the nature of the cargo. Household goods are obviously packed differently, and they will vary, unlike many commercial shipments headed through the ports. Page 39 of the petition reviews this detail in part. Delays arising from governmental inspections of cargo before free time expires are beyond a shipper's ability to control. The shipper or consignee has no control over the decision of the government to inspect a particular shipment or to the timing as to when an inspection may occur. This is particularly true in the case of household good inspections, regardless of whether all the paperwork is there and whether it's packed properly or not. Household good shipments are unique from the majority of commercial and retail shipments, as the contents are not for commercial resale and are often shipped at personal expense by a U.S. citizen without any foreknowledge that the clearance process through a U.S. port could result in thousands of dollars in extra fees for the government to clear the shipment. This guilty until proven innocent process unfairly burdens the shipper and the family in many cases that are moving household goods. These exam fees are unknown and therefore unable to be included in the quote to move the household goods. There's an expectation that there's a potential there, but there's no standard essentially for how much it might cost, both in terms of moving it to an intensive exam to be examined at the warehouse, or the time and delay that could be created as a result of getting it there. Packing of household goods are done by professional movers. When they go through an intensive exam, things are often yanked out. They're put back in, but there's no requirement that folks are trained at the warehouses to put them back in the proper manner, and they can be susceptible to further damage during the inspection process. The frequency of the exams cannot be understated. While we don't have 100% mandated as the earlier panelists did with the Meat Council, we've had members come to us within the past 6 months saying 75% of their household goods shipments leaving the country through the Port of Long Beach were taken apart as part of an intensive examination. Costs for exams can be $600. They can be $3,000 or $4,000. There's really no way to know. It just how long will it take? Will there be folks at the warehouse in order to do it in a timely and efficient manner? That being said, I am is asking the Commission to consider in any forthcoming policy statement either looking at future recommendations to the terminals of and the owners of the intensive warehouse, a flat fee, a max fee, some level of expectation. We're not requesting that all detention and demurrage charges be removed, as no one here has. Just that we have an expectation of what we might expect, particularly for our industry. We're just more susceptible to having these exams done, and it's often not done, on site. It's got to be picked up, it's got to be moved, and it's got to be sent over to the warehouse, resulting in more charges. So any policy statement that would look at, recommendation of how and when things are done in the exam world would be great. You all have put so much time and effort as an agency in looking at port congestion issues and meeting with all the stakeholders. We really appreciate that, and we look forward to working with you in the future. Thank you.
Thanks to all. Very good presentations. I'm going to start with one that's sort of maybe on the small side, but it just caught my attention. And that you were talking about chassis charges, if you recall. And as when you're caught at a terminal, this was again within the context of government inspections, etc. Now, the chassis holding the container that's getting inspected, the chassis people get paid, don't they?
My reference was to my reference was more directed to the steamship line and the detention charges for use of the steamship line equipment. Chassis charges do also come into play, and obviously it'll depend on who is the owner of the chassis. If that's a trucker, if it's the steamship line, if it's the rented chassis of the trucker.
So if I may add to that, because what happened was in the port of New York, New Jersey, that we're a little bit different with our exams than they are in the other ports in the nation. We actually have our exams done off-site. They're not done at the terminal. So in the past, when they were done at the terminal, believe me, we had problems when they were done at the terminal. They wouldn't get done on time. Everybody's pointing fingers. You never know who. There's no transparency in the system. Now they're being traded off to exam sites. But what happened was prior, you did not have to pay for detention charges as long as it was on the pier. Now what happens when they get moved off to the exam site, as soon as that container is moved off the pier, the clock starts ticking for the detention on the free time on the container. And normally, it doesn't get out of the exam station within 1 or 2 days. So it's there for 2 days, 3 days, clock's ticking. So by the time it comes out of that, now your time's starting on the detention with the line. So it takes another day or two to go to the BCO, get unloaded, and get back. So then they get a bill a couple months later. They get a bill from the line saying you owe detention charges, where previously they would not incur those charges.
Okay, but I guess the rather loose line I'm sort of pointing to there is a principle where the chassis provider, everybody's nodding their head. Well, of course, they get paid per day, but the owner of the container doesn't get paid.
Under current situation now in the Port of New York, New Jersey, the owner of the container is getting paid.
I said but your proposal is that they not be paid.
We really question why the change even. At one time, it was part of the port process. Now it's no longer part of the port process, and the container held at the examination site, it's a wild card. When an exam in properly efficient circumstances, it will turn around fairly easily. But in moments of port congestion, it's very difficult sometimes, even once the container is released, getting it back to the terminal. So it's a situation for us that's totally out of the control of the importer. It does relate back to the issues of security for the nation. Clearly, there's a need to examine products. This really should be somehow treated in a different way, so these costs are defrayed maybe by a larger community. That's not something necessarily that the commission is going to be able to solve, but the point here is it's definitely a charge that one importer or one BCO should not have to defray. It is totally out of their control. So when we look at the set of circumstances that are beyond the control in which punishing costs occur, that is one of them.
So what would be probably reasonable is that the container, the charges would start when the cargo is released at the exam site, because then the BCO should make every opportunity to be able to pull that container from the exam site as quickly as possible to be able to not incur charges. They're not going to let the product sit there for 3 or 4 days in any event. So then this way, they could avoid those charges. If it goes out of the exam site, they have 48 hours to return that container. They'll be able to get that container back within 48 hours.
Mr. Roach, your example of 3 different times having to go back, how did that end up getting resolved?
On the third time, they got the container and they left, but they paid demurrage charges each of the 3 times, total of $1,700. It has not been resolved since November. So we even had waiver or extension of free time during that period that was acknowledged by the terminal after the fact, and we still can't collect it back. It's one of those, and I used that example specifically because it had a lot of components to it. That you have to pay cash on the barrelhead. There's no ability to go in and really argue the fact after, and it was a escalating type of a condition that just kept getting worse and worse and worse. I will say, and I did point out here, there is that risk that we assume that there's waiting time, and the trucker does not get compensated for that. There's dry runs, and the trucker does not get compensated for that. And so if we don't get this thing resolved here shortly, I will be going to Caters.
Because that's above and beyond the $1,700, to be
Correct.
clear.
Yes, the $1,700 is the straight demurrage and detention time. Just demurrage time, I'm sorry. Straight demurrage.
Appointment systems. I know in the Port of New York and the group that has been working up there for, the last 3 years, I think. And from what I understand, doing good work, it seems very careful as they move forward. This is a polite way to say, but I asked previous panels, the appointment systems, how often are you seeing that you make a call for an appointment, or your designated dray company does, and they're told, and it's not on the 5th day at the 11th hour, it's at a reason, because there's all sorts of ways that things can get gamed. We all agree with that, but that you make a reasonable request at a reasonable time and you're told there just are no, we're not talking about snow, we're not talking about anything else, no windows till next week. How prevalent is that?
So from our standpoint, out in the West Coast, we're seeing that on a regular basis.
Okay, well, what does regular basis mean, Mr. Roach?
I wouldn't be able to put a number on it, but at least monthly that we're seeing that there is that kind of a condition. I would also say that I have another live example right now in Dallas where there's just no chassis. So the container comes in, the carrier has the responsibility to deliver that container to us. They have to use the fleet chassis, they're the pool chassis out of Dallas, and we're told all of last week until Friday that there was no chassis available in Dallas, so you're basically in demurrage for 8 days. Very similar to the appointment system. It's just there's no availability for you to go and get that container. Finally, on Friday.
Are those, so we just stay with that, you're saying those are door moves and there's no chassis?
Merchant haulage, but you have to use the pool chassis provided at the ramp.
Okay.
You cannot bring your own chassis.
I see your point.
Yes,
Okay.
because they are a wheeled operation, but they've got everything in the stack now because there's no chassis. Frankly, the chassis went from Dallas to Houston, and a lot of them haven't been returned yet, so there's just a big shortage of chassis in Dallas. It's a similar kind of situation with the appointments that, basically the last free day was Friday the week before, and we didn't finally get a chassis until Friday the week of, and no agreement to waive demurrage until that final day. It took a week worth of arguing with the steamship line to get them to waive the demurrage so that we can go in and pick it up, which we did within 2 hours and delivered that container. But if we hadn't, we were then going to lose free time on the following day and go back into demurrage again. So we quickly picked it up.
Okay.
If we could add further, this kind of an exercise throws additional inefficiencies into the system, and there's a tremendous hidden cost to all the parties.
Understood. Commissioner?
Thank you. Do you know who operates that chassis pool?
The chassis pool in Dallas, I believe that is Track, is the operator. Hapag-Lloyd was the steamship line, and it's the Dallas Rail Ramp.
In your experience, assume that the commission was to accept the petition guidance. What would you expect the consequences to be on behalf of the terminals and the steamship lines? Do you have any?
Yeah, and I don't think they would be bad consequences. The consequences that I would expect is that there would be a greater increase in free time so that the terminals or the steamship lines are not actually collecting when there's issues that are beyond everyone's control, not collecting the demurrage intention. So I don't think that when we talk about consequences, it's an extension of free time. To them, it's a consequence of not collecting the money that they're collecting today. But should they be, is the question that's on the table.
We would actually, if we may add, point to the situation with the cyber attack on the Maersk system. It was absolutely crazy in the Port of New York, and free time was sort of extended incrementally. It seemed there was an indication on the part of the terminals that definitely storage bills were issued. But at the end of the day, the free time was extended to accommodate the period. And we truly believe that kind of flexibility, which was a very positive thing, was a direct result of this kind of a discussion.
So, Cameron, what is the issue most often litigated in these cases? In your experience?
In my experience, the actual litigation goes to those containers that tend to be abandoned for a period of time because a collection of the demurrage has actually worked to defeat the intended the intended object, which is to expedite the delivery of the goods. It has had the counter effect of creating merchant disputes between the parties. Recently litigated approximately $2 million demurrage case where there was in-transit demurrage assessed on an export shipment. There was a request by the merchant to not send 150 ocean freight containers to the port that it was originally consigned to, but to a different port, because the merchants had made an election to do this. They requested a quotation from the custodial carrier of what would that diversion cost be. They got a quotation. In reliance on that quotation, they then acted. When the containers showed up the following week at the new port of destination, they were told that the charges included $75,000 in demurrage that was assessed at the transshipment port. The irony of all of this was that amount was actually not accurately calculated, and it took the steamship line over 2 months to admit to that. And in that course, of course, the demurrage at the new destination port only increased. Commodities that are exported by the United States tend to be raw commodities. In this case, it was untreated logs from the south. It went out of Savannah, Georgia, largely. And you can imagine what happens to raw timber sitting in a metal box on a Chinese port in the middle of September. Nothing good can come of this. But none of the parties accurately on the carrier side reported the amount of demurrage that should have been assessed, that it was even being assessed, and when asked what the basis for it, were given misleading and incorrect answers. It was not until forced in litigation that we were given a direct answer to the question of what is the basis of these charges. And it's that kind of inefficiency and a lack of accountability that I think is going to drive large litigation. These cases of per diem and smaller demurrage amounts, frankly, don't, if you do the math on it, tend not to work out. But I will say that smaller amounts, especially in the aggregate during port congestion, especially on per diem, it is almost impossible commercially to deal with that because of the UIIA agreement that is in place with the motor carriers. That agreement requires arbitration. And I would note that that arbitration clause has been deemed by a court in California and in Texas to be both procedurally and substantively unconscionable. So you have commercial agreements that are been litigated. The method of resolution has been deemed to be unconscionable by at least 2 courts. And this causes me to wonder, is there a viable commercial solution, at least in the question of per diem on specific cases, especially when you have to submit it and can only submit them approximately, I believe the number is 5 at a time. And you're really subject to the contractual overreach because you have basically the carriers driving the terms and conditions of the UIIA. And while there is opportunities for some negotiation, I would argue that the footing is unequal, and I think the courts have validated that position.
Thank you. And one more briefly, how does the California law operate that removes the demurrage and detention charges against truckers in certain cases?
Yeah, there's a California law, California Business and Professions Code, that it was written to address intermodal motor carriers
Right.
being assessed demurrage during times of gate closure or inaccessibility
Yes.
due to forces generally beyond everyone's control, and also labor and in other circumstances. But the bellwether of that legislation, that law, is gate closure. And what we have here is if you ask the terminal, they'll say, well, we're open for business.
Okay.
The open for business sign is there, and you become in a huge argument about whether they were truly open or was the gate closed, and what does that mean?
I see. So it's not as good as it sounds for the trucker.
That bright line, we've been talking a lot about trying to make a one-size-fit-all situation. That's why we have case-by-case examination of issues. Regulations never historically have addressed all facts in all cases. They are broad. And then we look at the facts and we make a determination based on the fact and circumstances of what is or is not inequitable, and if the gate is closed or not closed.
Thank you.
And I think that's the point that Commissioner Maffei and several of his questions has been trying to drill to, but
Thank you, Mr. Chairman. Just a point of clarification, Mr. Roche, where are you? Where is Mohawk Global Logistics headquartered?
In Syracuse, New York.
Well, the best medium-sized city in the United States.
That's right.
But perhaps tied with Louisville. Kentucky.
he's shameless.
It's off topic a little bit, Mr. Roach, but do you consider the Washington, D.C. weather to be cold or winter-like at all?
It's very comfortable right now,
But I
including a little snow we might have later today.
I concur. I do want to ask you, though, some serious questions about what you've been saying about risk, because you've been talking about sort of there's a level of risk, and I've been trying to unwind kind of what it's reasonable for the shipper or intermediary to assume. In fact, part of the advantage of hiring an intermediary is that shipping, particularly internationally, is somewhat unpredictable and risky. And so it's not something maybe to just go into. You want to hire an expert in it. So it's in fact part of the reason why people hire all of you. So how do we figure out how much risk is reasonable for you to assume of these unpredictable things, and where there's a level of risk that if it's passed on to you by carriers or MTOs is unreasonable?
Yes. So I would have to say, when we look at risk, and it was brought up earlier today by Mr. Corey, that the carriers and the MTOs assume an awful lot of risk. The carriers, especially if they have to park their vessels, the cost for that is enormous. MTOs, if they can't flow their terminals, the cost to them also enormous. The extra things that they have to do, and we heard about shoveling the snow and that sort of thing. I think that when I bring this point to the table, what I'm really trying to establish is that we're not asking an unfair burden on them because we do have risk as well. We're asking them that they cover their side and we cover ours. When you look at some of the chargebacks that our customers face when they can't deliver contractually their container on time, that's an enormous risk that BCO takes. When you look at the truckers they get paid by the run. So when they deliver that container, they get paid for that. But they don't always get paid or sometimes never get paid for dry runs or for waiting time, the time that they spend in line. It's just accepted that that's part of the risk. Well, 8 hours is unreasonable. So where do you draw the line and say that, okay, we heard 30-minute turn times, we're never going to see that again, but a 1 hour or 2 hour turn time in a terminal is proper, and a 4 hour wait in line or an 8 hour wait in line, or in some cases even 10, which we've experienced in the Port of New York in recent years, that's just not proper at all. We can't compensate those drivers, and then to add insult to injury, we end up with demurrage charges because we couldn't pick up those containers. The example that I drew before about doing a 25 container a day flow for the course of that week, and I can't pick up those containers because of some weather event or for whatever reason, the meltdown of a system or whatever it is, I end up then with 10 or 15 or 20 or 40 containers in demurrage. Is that risk mine? So I don't know if I've answered your question, but I think I have to say that there is risk on both sides, and we don't charge them for the dry runs, and we don't charge them for the waiting time that we have.
Yeah.
You know, we fight the demurrage and detention with the geofence stats that we can keep on this, but we don't have a way of going back and charging them because they didn't perform. We're actually performing. But we don't need to be penalized for lack of their performance.
I think you addressed the question somewhat, and feel free to jump back in here, but let me ask Mr. Vickers, because you have sort of a more precise business and that sort of thing. It seems to me that the transporting household goods is inherently a very high risk from a financial perspective. So just trying to examine it, isn't that part of your business? I mean, isn't it included in your business model, this level of risk that there might be an inspection, and if there's an inspection that could cause other, and to the extent it is, I mean, can you pass some of the cost of that risk on to your customers? And is there a market failure somewhere along the line that I'm not accounting for?
Yeah, well, so some of the cost is obviously passed on. It's difficult because there's very little leverage. Okay, so these are all one-off shipments. You're not going to keep moving in and out of the country, and so the leverage is the kind of first disadvantage on what's there. The second part is understanding the cost. Is there a greater chance that it's going to be examined? Yeah, probably, versus a CT pad, a commercial shipment coming through the ports, or even leaving the ports in the case of Long Beach, as we've seen recently on the intensive exams going out. So there's the risk there, absolutely. What's not understood is how much is it going to cost? We have anecdotal information from our members that would reach as high as $4,000-$5,000 for the exam. That's not including any of the free time lost in getting the household goods to the offsite exam, or waiting if we have to wait to have their staff go through and examine it, put everything back then and put it there, not to mention the equipment rentals that come with that as well. That's all part of the process. So yes, to answer your question, there is a greater likelihood of it. However, understanding what those costs would be is still unknown. And, as a company, packing up properly, having all the documentation, and then just getting pulled for a random, government inspection, it's not necessarily fair, I guess you could put it that way, to have no understanding of how much it's going to cost or who's going to end up paying for it. Obviously, the cost goes back to the moving company. The moving company will sit back with either the family to say, well, we've got these costs coming in, or if it's a corporate reload, they might sit down and be able to work out something with the company.
Right.
But the parameters in themselves.
But aren't there insurance products and things like that you can buy? In other words, okay, they're not. So, Mr. Quinn, feel free to come in here, obviously. But are there reasons why there are not? Are there reasons why your organizations don't offer insurance products that would allow?
They don't exist.
They don't exist. Well, you could create them, right? I mean, isn't that what trade organizations do in other industries? I mean,
Hard to get underwriters to accept delay.
Yeah.
Physical loss and damage, absolutely no
Yeah.
problem at all in the
Okay.
market.
Right.
So there's
But
good. That's
delay,
helpful, actually.
The
There's a
nature
big
that we're talking about here is a shifted risk that underwriters will not accept.
Yeah, because it's so difficult to predict.
And where's the harm?
And where's the harm?
It becomes a consequential,
And you don't know what it is.
difficult to measure.
Okay, so several of you, I mean, I think Mr. Roach mentioned unilateral power. Somebody on the last panel mentioned oligarchy, oligopoly. Look, I mean, maybe I'm anticipating some of the arguments tomorrow, but many carriers say that they've been struggling with years of losses because of the low freight rates. If they have so much market power, how come they just don't increase their freight rates? And actually, Mr. Roberts, you mentioned, this is a backdoor way, and that if they would just include it in the rate. I mean, why wouldn't they just include it in the rate?
Well, I think that's an excellent question for them.
I'll ask it to them.
Because they're in the best position to know their rate matrix and what their cost structure is. I think from an NVOCC's perspective, we look to the carriers because the carriers, frankly, dictate to us what the rates are that we can get in a service contract. or in an NSA or on a spot market rate for an NSA. So all of those tools are available to the NVOCC, but we're not freight rate makers. We're takers in the marketplace, and we seek to make a fair living off of the $100 differential that we can often make in the transaction.
So as a practical matter, if suddenly the rates went way up, it's not like you wouldn't be able to change it. It's the fact that they're, I guess, relatively low compared to historical standards is just, it's good for you, but it's not something you can control or go to somebody else.
I think the margins that the NVOCC is able to, use the euphemism, enjoy, are based in not on what anything other than what that value of the service is. It's not a markup that is, we can't say, okay, the freight rate increased. You know, my experience as an OTI selling rates, when I was in the industry, we couldn't just mark everything up 30%. I mean, it didn't work like that. We had to publish a tariff. We had to compete in the marketplace, and certainly now with the NSA, we have that shorter term, but we undertake also risks that the market rate may change because of surcharges or something else that we can't pass through.
I guess one of the things I'm trying to ascertain is, as an alternative to a substantive rule describing what practices would be unreasonable, if there were rules to increase transparency or set procedural requirements related to how these, whether there's practices, whether that would address some of the issues in the petition or not. In other words, and it gets back a little bit to our discussion about whether the carriers are using this as a profit center, or whether these are, if there were more sort of transparency requirements, so that they had to tell you how much of these charges they had to then pass, pay for, or how much were profits or whatever. Go
I
ahead.
can address the profit center issue.
Yeah.
I mean, under the UIIA, if I take the container and interchange it, and I move it by truck to an inland point, and it's involved in an accident, and it's a constructive total loss, under the carrier's terms of the addendum to that agreement, there would be an adjustment based on the book value and depreciation of the asset, and that's what I would owe. I would estimate that the rough numbers be $3,000, maybe a little more, maybe a little less, depending on the line and the condition of the container, whether it's a 20 or a 40.
Right.
Demurrage at $350 a day, 10-day period, you're exceeding the complete value of the box. I might as well get in an accident with it. I mean, pragmatically, that's an economic decision that's not ridiculous. Just like during the course of this, we actually advised the client to consider the possibility of letting cargo go general order. Rather than make an entry and letting it go into the normal stream, it would have been more economically efficient to have customs seize the box as abandoned merchandise, move it to a general order warehouse, and make an entry. When that is a realistic opportunity to consider, your market is broken. Yeah, that's crazy to do what I just said because of the cost, but yet those costs would be lower than the cost of $350 a day.
Even if you have to change some of the names, I'd love it if you could provide that example. That's very interesting to me.
I can't.
Okay. For the record, I guess. I think trying to work out how we would get our hands around where even this definition of reasonable, I think, is a challenge. Anyway, I'll finish my questioning. So thank you, Mr. Chairman.
If I can contribute,
Yeah.
I think that transparency should be one of your essential focuses, because I realize how difficult your job is, because you have a lot of people yelling and they want some help, and then you got to figure out what the hell to do. So
amazingly, no one makes money in this entire industry. I don't know how everybody stays employed.
You guys deserve a raise, I'll say that. But the transparency part, and I have a lot of sympathy for the gentleman from the IAM, because they have a terrible time, because in reality the household goods shippers roll one-shot deals, and most of the shippers have no idea, no clue what to expect. One thing I'm hoping that in whatever policy pronouncement that you have, you see, I do a lot of export. In reality, export demurrage for me is extremely rare. I see it more overseas, which is not in your jurisdiction, but I'm hoping that there might be a ripple effect for what you do. Perhaps you can analyze and provide statistics as to how much demurrage is costing and at what ports they're costing. That kind of data that you could perhaps broadcast out would be good. But for example, I had a client who had a shipment to France, and it has you have no jurisdiction in that. But about a month after his shipment landed and was cleared and delivered, he gets a bill for $1,200. He didn't even know about it. And sometimes I've seen in this industry where people would get bills after the cargo has been delivered and it hasn't been held up. But something comes out of the blue saying, "Oh, there's something more," So transparency is the main thing.
Yeah, if that case does involve the entities we regulate, caterers might be able to help. Obviously, I know you know this, but I'll say it for the record. And even that's part of the reason why we have it for those kind of one-offs.
The household goods industry, they're all one-offs, and mostly it's going to be borne by the cargo owner. People, their companies kick in for examination. If they're lucky, maybe they will, but 95% of the people will have to pay it themselves.
Okay, I have one further question, but I'll yield unless there's time. Well, just, this whole issue of the contracts and whether you have any control over them. It seems to me that has anyone ever tried to, or any of your members, just tried to renegotiate some of these contracts? Or in fact, are the contracts just not accessible to, are you not parties to the contracts that we're talking about? In other words, we talked a little bit today about contract law, and it sounds to me these contracts basically are, of course, designed to protect the MTOs and that sort of thing, but contracts can be renegotiated. You can say, well, I'm not going to follow that contract. We need another contract. Is there has there been any attempt to go back and renegotiate these contracts after one of these ostensibly unreasonable issues? Or simply no opportunity to?
Yeah, I'll take that. We do negotiate some contracts, and members of our association negotiate contracts. I think you heard before, tends to be a boilerplate, a reference also to the tariffs in the contracts. These are things that are very, very difficult to change. And trying to change the boilerplate, especially at the size level that I'm representing here today, the medium to smaller size shipper and NVOCC. And then when you ask in the context of demurrage and detention, that's not even a discussion in the contract. That's a contract between the MTO and the carrier. So we don't have a seat at that table. We don't get to negotiate that. Free time, extended free time for detention at a warehouse, we can negotiate that into a contract. But on the port, demurrage, not a chance.
Thank you again.
Comment then question. I understand your point, Mr. Roberts, about book value of a container, but let's recognize, especially as I understand the newest tax law, that you can write off certain investments. The book value on a container, I assume, I'm not an accountant, but I've been in business, would go to zero because it's written down to zero in 1 year. Book value is not the market value or the value that that piece of equipment could earn if it continued to work in the trades for the next 3-4 years. But I understand. Let me go back to Mr. Quinn, because you were right on the edge of something that has been interesting, and there's certainly going to be some questions for tomorrow. So if the fellows are still here, they can make note. So a part of the purpose of Shipping Act, as Congress gave it to us, is to whatever extent possible harmonize with our trading partners, other countries. What happens overseas? Would there be this kind of meeting in
It's very interesting.
Shanghai, Rotterdam, etc.?
Because I'm in this business, I've always loved international. This is why I'm in it. I like it. And I investigate a lot myself. And I look at different ports in different parts of the world. And I was remarking recently in northern Brazil, there's a port, and they were advertising their services, and they said 1 month free at their ports. And I said, my God, that's terrific, And then I compared that with some ports in India, and they were giving 20 days free. But of course, in India, it takes so damn long to go through customs, they have to do that. So it would be perhaps instructive for the Commission to look at some of the practices elsewhere. I don't think that some of these other entities, other countries in Europe and so on are really doing what you're doing here, but I'm hoping that there can be a ripple effect where the FMC can in fact take a leadership role, not necessarily put down harsh rules and regulations, but a guidance, because I've seen storage demurrage in Europe, and perhaps if they say, well, this is what the FMC just did in the United States, well, we might try to do the same thing to harmonize. So I'm hoping for the ripple effect. I can't really give you all the answers. I'd be happy to look into it and have an ongoing dialogue about this. But I don't think that anyone else that I've seen is having this kind of meeting. And I think that the issue of demurrage is incredibly important. Most people in the public have no idea. It took me years to figure out how to spell it. 1M, 2, so the people in the general public, especially household goods people in the trade know it. It's like asking a priest, what do you think of the devil? Like, wow, it's terrible. But exactly right. But with household goods, that's where you get into the fairness things, because people just don't know, and they have no bargaining power whatsoever. They're simply stuck. And unfortunately, sometimes the OTI and the packers and the movers, they're the ones who get the blame. But it's really part of what happens. And for example, I had an agent recently in Switzerland give me a rate. And they said from Rotterdam to Geneva, it's going to take 18 days to have it cleared and delivered. However, most of the carriers are only giving maximum 10 days. So on their quote, they have to say that demurrage is a certainty, and they can't tell you how much it will be. So a lot of movers will simply give a sort of like, this is what our rate includes, and this is what the rate does not include. And it never includes demurrage, and no one knows how much that's going to be. So it's a big, people fear the unknown. And that is it's a problem. So the amount, you're never going to cure any of these problems, but to shed light upon it and to give broad direction would be very helpful.
For example, Long Beach has been cited, I think, a half dozen times in terms of government inspection and their policy, which I assume you all like. But your point is spot on. Of do they give unlimited free time as long as the government may take? Do they just recognize it may take 3 extra days, and then at some point free time begins to run? And I'm sure there's all sorts of variations there. But your point is the allocation of risk, and when does it shift from one side to another?
It's pretty strict. I don't think that they really don't care for whatever reason. They're just going to say, this is how many days, and it doesn't matter if it's because it's going to be inspected or what have you.
My last comment is this, that I think we have just one mic on would help. That Mr. Roach was one of the first notes I made about transparency, and then Mr. Quinn, you picked up on it again in your all's discussion, and I just have an open question that I may want to explore with my colleagues about: is there a transparency process that we may want to engage in to help bring? There's a lot of very good. Today's been very instructive, very helpful. But is there a process that we might capture this on a rather strict basis? And Mr. Roach, when I said, so how often does this on the appointment question? And I fully appreciate you can't put a number on it.
Give me a little time. I can come back with some stats.
Okay. My colleagues, anything else? It's been a good day.
Good day.
Let me do a little housekeeping because of the weather. Ashley, I saw you come in a little late. Is it already starting to snow?
No, Mr. Chairman, it's nice and like crystal.
And where are you
Is it-
from? Okay, okay.
No, I didn't mean to pick up, but when I saw you come in, I wonder if it's already, but they're predicting snow tonight. People with more tenure here in DC than I only have 8 years. Our guess was if it's only 1 to 2 inches, it may be a 2-hour delay from the government OPM. If that be true, then what I commit is, staff, you're going to grit your teeth. Please try to get in as early as possible. Understand would be a 10 a.m. start time. And I will try to be here at 10, and we will start at 10 o'clock or as soon as we have the first panel in the morning and enough FMC staff to work all the electronics, et cetera, et cetera. If it's a full shutdown, we're I assume just going to have to figure out what we do from there.
If it's more of a delay than that, we'll certainly post it on the website right on the front so you can see it.
Yep. For, I guess probably most everyone here knows, if you just go on your Google OPM and it will come up immediately. It'll say status. You click status, and they'll tell you what the work schedule is for the day.
So 2 hours or less delay. We're
We'll-
on time
We'll be here.
with reasonable,
Let's do it.
yeah. Okay, good.
Yep. Does everyone, any other comments, or everyone agree on that? Yes, ma'am.
Just a separate comment, just to remind participants, if there's any information that needs to be submitted for the record subsequent to the hearings, you have until the 26th, next Friday, to do that.
Very good. Thank you again for all the witnesses, and they're excellent, and look forward to tomorrow. So thanks again.
Thank you, Mr.
4 o'clock, we're adjourned.
I
got something from one of our truckers in Northern California. He has terrific